Today we're going to look at contract law. This presentation is also going to follow the Ignite format, where every slide advances within 15 seconds. To give you an example of what you might do for your final projects. As discussed previously, there are 5 things required for a contract: offer and acceptance, a mutual intent to enter a contract, consideration, which is money, typically capacity, and the thing has to be legal. So an offer is a promise that the offerer is making. It can be written or spoken, and it can be withdrawn at any point up to acceptance unless terms dictate otherwise. It's not indefinite, it will have a limited term, and if it's not accepted, there could be a counteroffer. To accept an offer, you have to be clear in how you say that or in your actions. The acceptance occurs when the person making the offer receives the acceptance, or when it's posted, if it's by mail. And the governing law is the place where the contract was accepted unless stated otherwise. Mutual intent means both parties meant to enter into the contract, and is basically assessed by whether a bystander observing the process would tend to agree that both parties did intend to enter it. Consideration is basically a thing of value or a thing that has equal negative components to both parties to be exchanged. Both parties need to do something. It doesn't have to be money, but it could be benefit or detriment to both parties. The size of that consideration is not important, but without any consideration, there's only a promise to do something. We'll talk about equitable estoppel, which is an exception to that on the next slide. If you bid for work, the tender itself, when sealed, is considered to have consideration. In the case of equitable estoppel, if two parties have a contract and then the terms change, but both parties act as if the terms have changed, and then when one party relies on that change, there is said to be a gratuitous promise. If the first party then tries to re-establish the original terms, they are stopped from that. The 3 cases that really establish equitable estoppel are Commonwealth Exploration, Owen Sound Public Library, and boroughs. These are all provided in the way of links on the middle page. Capacity deals with whether you're actually in a position to enter a contract. Children generally can't enter most contracts, although they can certainly buy food and things. If you're incapacitated, you may not be able to. If the contract purpose is not something that a company is able to fulfill, they can't enter a contract. And finally, if the contract is not legal, then it cannot stand. And so non-competition clauses are one place where legality of purpose often gets challenged, where an employer is asking something unreasonable in an employment contract. There are 2 case histories detailed on Moodle which cover legality of purpose of a contract: Wellesley versus Collins and Lyons versus Nortari. And they specifically deal with things like non-solicitation clauses versus non-competition clauses. In the case of misrepresentation, if it was innocent, then the damaged party could get costs back from entering into the contract. If it was fraudulent or negligent, they can actually cancel the contract and claim for damages to put them in a position if they'd never entered a contract in the first place. So fraudulent or negligent misrepresentation is if a false statement is made that was knowingly false, which was made with the intention to deceive, and which caused the plaintiff to act, which caused them damage.